In the early part of this century, especially in the South, evolution was really not taught very much in the public schools. As many of you know, in the 1920s, the state of Tennessee passed a law forbidding the teaching of evolution under pain of legal penalties. And a teacher named John Scopes was worked with the ACLU to teach evolution and then arranged to be prosecuted for it. And the hope was that the case would eventually go to the Supreme Court and it would be thrown out and they would have something settled. Things never work out right, or often don't at least. Scopes was convicted, which the ACLU wanted. They appealed, which they had sort of planned to do, but unfortunately the judge, who was not one of the brighter bulbs of jurisprudence, had fined Scopes $100 upon being convicted. And it turned out that according to Tennessee law, a fine of that size had to be imposed by the jury. So the case was thrown out. Scopes's conviction was reversed, but without any sort of ruling at all on the merits. And so all of this effort was sort of for naught. It's often depicted as a great defeat for the creationists, even though Scopes was convicted, because they underwent a lot of ridicule in the papers, and became the fundamentalists became sort of a byword for ignorance as a result, partly of H.L. Mencken's writings. It's not widely known to what extent the creationists won. A friend of mine, historian of science, who used to be at the University of Minnesota, and some other historians of science have looked into this and looked at biology textbooks from before and after the Scopes trial. And from that time onward, the amount of evolution in biology textbooks simply declined very, very steadily. One of the first tricks was to remove it from the index. You look in the index of a biology book, and the word evolution is not there. This continued on up until the 1960s. By the way, the Tennessee law was not the only one. There was also a similar law passed in Arkansas in 1928. And this law remained on the books until 1968, when the Supreme Court threw it out. It was challenged by Susan Epperson.